Good morning. Today is January 10th, 2025. Welcome to another episode of Legal Grounds Morning Cup. I'm your host, Texas consumer and real estate attorney Benjamin Sanchez. Today, I will briefly discuss the most important thing you should do when you are sued. This week, I received an unusual number of referrals for people who have been sued and not knowing what to do or how to address it. Some have insurance, some don't. Uh, Yesterday, we talked about the fact that you need, when you have insurance, that one of the duties of the insurance company is to defend you. But a lot of times, people can't wait for that, or they just don't have insurance that will cover it. So when you're sued, for example, especially when you're sued for an eviction, you may be sued for an expedited foreclosure in Texas. You may be sued for debt, a commercial dispute, business dispute. The most important thing that you should do when you are sued is to file an answer. As simple as that sounds, sometimes it's not that simple. People just, don't forget about it. They think that it'll magically go away, or if they don't do anything, somehow the court can't act on it. If you do not file an answer in a lawsuit, the other side can get a default judgment. It's not automatic. They have to go through a process to get that. But if they go through that process, they can get a default judgment against you without you ever appearing in the case. So it's important when you get that lawsuit and you have that citation on it, it's going to tell you how long you have to answer the lawsuit. Now, it's very important to read that citation, because that citation, that front page that tells you that you've been sued, will tell you, generally speaking, when you have to file a response. Not an exact date, but it'll calculate it from the date that you were served. So it's very important to note when you were served with the lawsuit, and then calculate based upon what's in the citation what that deadline is to file the answer. A lot of people don't know exactly what to say in an answer. The Texas access to let me check it here. The Texas Access to Justice Commission. Sorry about that. They have developed some forms for people who don't have attorneys. Now, obviously, I think that if you've been sued, especially when there's an attorney on the other side, you should definitely hire an attorney to represent you, because quite frankly, it's like going to a gunfight without a gun. Okay. Attorneys, that's just, courts are their playing field. They know all the rules, and it's just not really a fair fight if you try to do this without an attorney. But one of the things that can help you, though, is filing that answer. So what I thought I'd do today is show you one of the forms that the Texas Access to Justice Commission has developed for people who may not have an attorney and don't know exactly how to file an answer. So let me pull this up for you. So as you can see, this is a defendant's answer here. And you can tell there's three different types of trial courts in Texas. There's the district court, the county court, and the justice of the peace court. And so here at the top, you will see that there's a check box for which type of court you're filing in. So this form is meant to be used at any level of trial court in Texas. And then as you go down, it will tell you what this is. And let me see if I can scroll this down. So it'll give you here instructions at the top, and then it will tell you how fill in the blanks. So you can go in here and fill in the blanks. So for example, most people don't know, but it's required that you give the last three digits of your driver's license number and your social security number if you have them, or you can check the box that says, that you don't have them. The most important thing here is this general denial. So this is automatically on the form, no questions asked, because that's the minimum standard that you should definitely have in your answer, that you generally deny the facts and the assertions that have been filed against you. Doesn't mean that you specifically deny every little fact, but it puts the issues in question so that when there is a trial or a hearing, that the other side actually has to prove up their case, right? And the reason for that is that because some people, when they file a handwritten answer, they basically admit to the other side's cases and they, causes, and they want to somehow explain away why they can't pay. So I've seen this a lot in debt cases, for example, where you're sued for credit card debt and you file an answer and you said, I know I owe, but because of X, Y, and Z, I'm unable to pay. And so that does not put what the plaintiff has said into question, and therefore they can also get a judgment because you have not denied anything. So this general denial is very important. That's why it's included without any kind of extra lines or check boxes, because it's going to stay there. And then you have here on this form, you have other pleas that can be made. There's the Texas Rules of Civil Procedure, the procedural rules that govern the judicial process in Texas, at least for civil cases. There's also the criminal procedure and the appellate procedure. But you'll see here it says look at Rule 93 of the Texas Rules of Civil Procedure, and if any of those things look like they could apply, then you want to put them down. Okay. These are specific pleas. So, for example, if you're sued for debt and you want to say that you actually paid some or all of that debt, then that kind of plea would be here. You do have to swear to that under oath, which is why it says that you must plead to that under penalty of perjury. And then if you go down to affirmative defenses, you want to look at Rule 94 of the Texas Rules of Civil Procedure. There are all these defenses here. I'm not going to go into what all these mean, but generally speaking, if you go to Rule 94 and do some homework or whatever, then you can try to figure out what those are. Okay, and then you keep going. It'll ask that that the plaintiff get nothing. You need to fill all this out, and you need to do it accurately. Okay. If you, my advice, and I've seen people say different things about this, but my advice is to actually put your email down, because Texas attorneys actually do e-file everything. And so if you don't put your email address down, things have to be mailed, and there may be times where something is filed and you don't get a hold of it. The post office doesn't deliver it to you because they're delayed. And so if you want to stay on top of your case, go ahead and enter your email address there, and then do this. You can do this unsworn declaration, which basically takes the place of an affidavit. You don't have to do an affidavit, and just go ahead and fill all this out. Okay, so the question then is, where can you find this form? And I will tell you that it is at, let me see here. If you go to texaslawhelp.org, TEXASLAWHELP.org, they will have some forms there for you. So it's very important that you do that. So it's very important, people, that you file an answer so you don't get a default judgment too many times. I've had people come to me saying that they now have a judgment against them. They didn't realize was going to happen. Or worse, I'm routinely approached by people who have garnishments of their bank account, and it all relates back to a lawsuit that they were served with that they never answered. The other side got a judgment, and now they're doing post-judgment collection, including garnishing bank accounts. And so they go to pay for something, or they go to their ATM or whatever, and the money's been taken. because the post judgment attorney has been able to find your bank account and get an order to seize the money, all without you knowing about it. So again, please, please, please file an answer. If you have an attorney on the other side, it's best to get an attorney for you. At least discuss that. And here at our law firm, we do offer consultations that don't require you to hire us for the actual representation. If you don't want, we do charge for that, but we do that so that we can dedicate our time to you, review your documents, and give you advice without trying to convince you to hire us. There have been many times, in fact, just this week, I've had at least 2 consultations where it was clear that the person did not need to hire me, but I gave them value for the consultation fee that they paid. In one case, we found out that the lawsuit against this person had been dismissed. In another case, I was able to walk through the eviction process for someone and explain that and let them know how to handle that if they wanted to do it themselves. And so we definitely encourage you to at least talk to an attorney. If you've been sued with an attorney on the other side, if you haven't been sued by an attorney on the other side, still file an answer no matter what you do. I hope this has been helpful. I do like doing these again. I look forward to trying to do these mostly every business day. Sometimes there may be reasons why I can't, for example, my court schedule or whatever. But I look forward to bringing you these kind of consumer tips on an almost daily basis here at Sanchez Law Firm. Thank you for joining us for another episode of Legal Grounds Morning Cup. Have a wonderful day and stay warm and safe. Thank you.